3, 2, 1.
Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott Talks Law. And in this episode you're going to talk about public international law, and you're going to dwell at the sources of international law. So the sources of international law are contained in the ICJ statute, or in the International Court of Justice statute, Article 38 sub-article 1. So the sources of international law are classified under 4 categories. And before we look at these sources, we must first know the history of international law. So that will take us to 1920, where the League of Nations was formed with the Permanent Court of Justice as its judicial body or organ. 1945, the United Nations was formed, and it had its permanent judicial body called the International Court of Justice, that was formed later on in 1946 as a replacement to the Permanent Court of Justice that was formed after the formation of the League of Nations. So the ICJ is the permanent judicial body of the League of the United Nations, or the UN. So there are 4 sources of international law. We have treaties or international conventions. We have customs and international customs, general judicial decisions and teachings of highly most qualified publicists, and you also have as another source of international law the general principles of law. So international conventions and treaties, these agreements that are entered into by particular nations or particular states, and these states must express their consent or the willingness to enter that particular agreement or treaty. So there is a specified subject matter that these parties are entering into, or the treaty that these particular parties are entering into. And another source is the international custom, and this is the evidence of general practices that are accepted as law by those particular countries. So these particular states accept a particular customs as their own law. And general principles of law, these are principles that are accepted by civilized nations or states, and they are principles that are applicable in those particular states that have accepted the principles. So there's no specific principle, they are very wide, and these are just principles that are accepted, and they are principles like respect to human rights, principle of good conduct, governing the good conduct. So these particular states they have accepted them as their own principles to govern them. So let's look at these 4 sources in detail so that we can understand well about the sources of international law. So beginning with the international conventions or treaties. So international conventions, whether general or particular, establish particular rules expressly recognized by contesting states. So according to the Article 38 sub-article 1 of Sources of International Law, it says that the court whose function is to decide in accordance with international law such disputes are submitted to it shall apply. So these are conventions, these are treaties that are practiced in particular. These are agreements that are entered upon by particular state. International customs, these are evidence of general practices that are accepted as a law, and general principles of law are those that are recognized by civilized nations, and judicial decisions and teaching of the most qualified is an example of sources of international law. So international convention and treaty. A treaty is an agreement concluded between states in written form and governed by international law. It can have any subject matter. A treaty to solve conflicts, to bring peace. It can have any subject matter. When signing the treaty, the states themselves must agree to that particular rule. So you have examples of treaties. These are like the 1945 United Nations Charter, 1949 North Atlantic Treaty, 2015 Pan-African Climatic Treaty, the Bauxite Withdrawal Agreement. So another form of international law, source of international law, is the international customs, and this is the evidence of general practices that are accepted as law, and it has 2 elements: the general practice and accepted as law. So general practice, this practice must become common among the states. It must become common among all the states, and this particular treaty must be accepted as the law, and that is referred to as the opinion juris. So accepted as law when there is a belief that certain practice is a legal obligation. So in this, there's a belief, or there exists a belief that this practice is a legal obligation. That practice is referred to as opinio juris, and you need to note that international customs will apply when there is no treaty, or in absence of treaties. So the third source of international law is the general principles of law, and this is quite abstract in nature because it is not written down, and it has a precise list. So this is a wide list. We don't have those specific principles that are accepted as law. So we have just examples of these principles, like the principle of good faith, that the conduct of the state shall be honest and fair. Another principle is the principle of respect and human dignity. The principle of proportionality, that certain matter must be proportional to the intention that it intends to achieve. If it is a punishment, this punishment must be proportional with the intention that it intends to achieve. So the fourth principle of international law is the fourth source of international law is the judicial decisions and teachings of highly most qualified publicists. So the ICJ statute article 38 sub-article 1D states that these are the subsidiary means for the determinations of rule of law, traditionally viewed as supplementary means used for interpretation and application of development of law. So those are the sources of international law that you need to know. We have formal sources and informal sources. Formal sources are those that are the sources that they contain this about concerning international law, and the formal sources that is just a backup to the formal sources of international law. Some philosophers may also classify these sources of international law as primary sources and secondary sources. So they say that there are some that are primary and the others that are secondary sources or secondary sources. So that is the end of my episode, and have a nice day.